Hi, everyone, and welcome to Raw Law. I'm Arkady Frekhtman. I'm a New York City personal injury trial attorney, and this is the show where we answer your questions and we talk about your comments. And we are here live from my office in Brooklyn, New York. And welcome, everybody. I'm sorry I'm a little bit late. I was actually doing a consult call with another client that was actually recorded as well. That's going to be an upcoming video that we're going to edit. And I think it was a really helpful one because it might apply to other people. The issues that I saw that this particular individual had were also issues that other people could have in litigation. How a case gets stuck, gets stuck in litigation, either because the lawyer that's handling the case isn't doing something correct, or because of other issues, the way the defense is trying to delay. And I've done other videos about that. So that'll be a good one. But I apologize for the delay. And I see there's a lot of questions in here already. So let's get right into it. Okay, the first one I see is from a Cali F. Cool. And he says, "Hi, Arkady. What is a case review?" So a case review, it depends on like what you mean. It depends on who's doing it or who's talking about it. Like in my mind, reviewing a case, like if I'm reviewing a case in my firm, it just basically means reviewing the file, speaking to the client, seeing what's happening with the case. So it could involve basically just reviewing the case and making a case plan, because you don't want to just be litigating a case blindly or without a plan. So some things could be very, very important, right? If you don't have that one piece of evidence, then you might lose the case. Whereas something else might be not so important. So you don't want to delay a case, let's say 8 months, just to get like one deposition or one document that might not even matter, right? You could just forget about it. So that's why it's important to like review the case and make a case plan. And so that's basically like a case review. So that's usually something that's done by the plaintiff's attorney in his or her own office as they prepare the case. And then Darren asks, "I went in to see an IME doctor. He had me sitting in a chair when he examined me. We both sitting in chairs when he examined me. And I had a nurse with me. The exam was 25 minutes. It's been 4 weeks now, still did not receive the medical report. In my case, there are multiple injuries. How long do they have to write up a medical report?" So that depends on like what state you're in and what the court order says. Like in New York, usually in the court order, it'll say the IME report to be provided within like say 60 days, 90 days after the examination. So yeah, but you want to send, if it's a serious case with multiple injuries, what I like to do is send a watchdog. And that's somebody who's independent that goes into the defense medical exam with you and sits there and watches everything happening and actually writes down. The doctor did a range of motion test, like he tested the range of motion. He did not use the instrument called a goniometer to test the range of motion. Then later, if the doctor's report says, "Hey, I did use a goniometer and like normal is 90, and this patient had 90 and I used the goniometer." Well, no, wait a minute. You have the independent witness who says he was there watching it and you did not use that instrument, right? So that's powerful. So now the doctor is a liar, or at least his credibility is called into question. That's very, very useful, because if you don't have that, then it's the doctor's word. And in some states, you may be allowed to video record IMEs, but in New York, I think you cannot. And in a lot of other states, you cannot. So at least send that watchdog. It doesn't really cost much, and it's a really helpful thing to do. So I always recommend that. I always do that, especially on the serious injury cases. But yeah, in terms of the time, usually it's just like, about 60 or 90 days. I had one case where it was against the city of New York, and they got me the IME report like years later. And unfortunately, the judge didn't even penalize them because they get a lot of preferential treatment because it's the city. So, and then Sengiz says, "Hi, after a settlement, let's say the hospital bills came out to 100,000. During negotiations, do they usually get reduced to below half of that amount?" Well, it depends on what the settlement is, right? How much the settlement is. And it depends on, there's not really any usual with negotiations, right? It's like saying, do cases usually settle for $1 million? Well, no, right? If you have a small case, like if you break your nail, it's going to settle for like, maybe $100 or $1,000. If you have a serious injury, then that commands serious money. It's the same thing with that. Like it depends on who's doing the negotiating and how, how good they are and all these kinds of things. But I mean, sure, if the settlement bills came out to 100,000 and then you have a good lien person that knows how to reduce liens and negotiate liens, it could be reduced significantly. So it won't be 100,000. It might be, like 50, might be 40, but there's not really any normal that I could say that goes for all cases. It also depends on the provider, right? Some doctors are more willing. Like, for example, if the case settles for only 200,000, but you have 100,000 in liens, well, you could say, well, look, all I can get from this case is 200. I can't get more, either because there's no more insurance or because the case has problems or because, of other issues. And that's all there is, right? So it's like take a piece of the pie kind of thing. So you can't take half the pie because the client has to get most of it. It's his or her case. I can't give you everything, right? So I know you're claiming 100,000, but you just have to take like 20 or 30 because that's your piece of the pie. That's reasonable because the whole pie is small, right? But if, like in the same case, the case settles for like 2 million, well, I can't make that argument anymore. They might say, well, I want the full 100,000, or maybe I'll only go down to 90. So it depends on things like that. But I think that analogy of like a pie and everybody wants a piece of the pie is kind of like a good analogy. But of course, the client has to get the lion's share. Okay, and then Virgo says, should I get an official diagnosis of my legal blindness to help prove liability against the grocery store for my trip and fall over the beer cases? It's in my driving record, but not medical records. Yeah, I mean, if you can, it's always helpful and you could testify about it. But if you have an official diagnosis and you have evidence, you want to always think, not really you, but really the lawyer should be thinking legally, well, how do I get this piece of evidence into evidence, right? Because you might have something that you want to use, but for whatever reason, because of a hearsay objection, because you don't have it authenticated, then when you try to get it into evidence at trial, they might say objection, and then the judge could sustain it. And then that really important piece of evidence that you need will not go into evidence and you can't use it. And then nobody will hear it. And then it's just like lost. And that's how cases get lost. So yeah, that's something your lawyer should be thinking about. And then Hope says, what's your experience with emergency ex parte hearings for a continuance? I heard that judges don't like them, or it has to be really serious for them to grant them. So a continuance is just basically an adjournment. So emergency ex parte means that somebody is saying it's an emergency, something happened, right? So they have to have a good reason, like somebody in their family is sick or something happened where they can't go to trial or they can't do the hearing now and they need a continuance, which is an adjournment. And ex parte just means that they want to see the judge alone without all the parties being there. So, I don't know what state you're in. We don't really have that in New York. In New York, if you ask for a continuance, you would do it by order to show cause, and you would put notice to the other side. So then both sides would have the opportunity to show up and argue, and then it's up to the judge to either allow the adjournment or not allow it. But I guess in some states, they have this ex parte emergency hearings for continuance, which, again, not really sure why the other side, whether it's like if the defendant is asking for a continuance, let's say, why wouldn't they inform the plaintiff and let the plaintiff come and make an argument as well? I'm not sure why it has to be ex parte, but that's basically my analysis of it. But I don't have too much experience with it because, like I said, we don't really have that in New York. Okay, and then Virgo also asks, how important is video footage? Is it detrimental to a case? If unfavorable or inconclusive, can it be excluded from evidence? Well, it can't be excluded because if it's unfavorable, it just is what it is kind of thing. If it's inconclusive, now that's different, right? If the video doesn't really show anything and it's hard to see or it's grainy or it doesn't really, then you can make an argument that it's not really relevant and it's not helpful to the trier of fact, which is the jury, because the video doesn't really show anything. You can't tell. Like, for example, if you have a video of the store, but it doesn't show the injury victim falling, you could say, well, what's the point of putting that in evidence? It's just a video of an aisle and no one's in it, no one's falling. How does that help, right? It's not going to tend to make an issue in the case more probable or less probable. So it's that would be excluded. And then I'm a Beam says, "Hi, Arkady. My lawyer, after 6 years, just told me he hired an outside lawyer to do my trial. Slip and fall, multi-level fusion, foot drop, hip tear, laminectomy, 7 million in economic damages value." Well, that's not good. You don't want a lawyer after 7 years to hire another lawyer, because it's two things, right? Number one, the lawyer that's supposed to do the trial is saying he can't or she can't do the trial. They're not really a trial lawyer. So they're going to have to just take the case and pawn it off to some other lawyer. Now, that other lawyer is coming in at the 11th hour. He hasn't been with the case for the last 7 years. He doesn't know the case. So he's going to come in, even if he has experience doing trials. He doesn't know your case. He doesn't know your human story. He hasn't been with you for the last 7 years. He doesn't know your injuries. He has to basically do like a crash course, kind of like you cram for an exam in high school or in college, and learn everything at the last minute and then go into court and do the best he can. But that's not in your best interest. So, and if you need more information on that in terms of value or what I think the case could be worth, it would depend, like I've said before, on where the case is pending, the venue, the full injury information, the full liability information. So the best thing to do with that would be to text me 347-566-9595. We could do a free consultation. I'd try to help you, but yeah, that's not a good sign. Okay. And then Barney says, "Best channel on YouTube." Oh, thank you so much. I really appreciate that. And Ben says, "Hi, Katie. Are the transcripts ever used at mediation or arbitration?" Yeah, of course. I mean, transcripts could be used for all purposes. So transcripts are sworn testimony. So once you testify in a deposition, your transcript is your sworn testimony. So they're mostly used at trial, because at trial, if you say something at trial live before the jury, but you've said something a little bit different in your deposition, which was maybe like 2 years before, what they're going to say is, "Look, you're saying today that the car that hit you was red, and it was a Toyota, but you were deposed back in 2023, and back then you said that the car was blue and was a Honda." So kind of like, are you lying now or were you lying then? And it's an inconsistent statement. So it's known as impeachment. They can impeach you by inconsistent statement. So that's how they use them. Now, arbitrations, sure, because the arbitrator has to make a decision as to liability. The arbitrator has to make a decision as to how much damages to give you. And the arbitrator's decision is binding, meaning it's final. So then part of the submission, let's say, that the defense will present could be a transcript and say, "Look, this person said this, and this." So that's going to be something that they submit. And the same thing with, mediations. Mediations are not binding, though. Mediations are like an attempt to settle. So with mediations, sure, they could make that argument, but ultimately it's up to like the judge will just do his or her best to get you the most money at the mediation. Like if you want $1 million, the judge will say, "Look, because of what you said in this transcript that I just read, I can't get you $1 million. I can get you only 600 because there's this issue here." And then it's up to you. If you want to take it, you take it. If not, you say no, thank you, and you go to trial. But you're going to have that transcript be a problem at trial. It doesn't disappear, So that's just how that works. And then Corey asks, "Is a delay tactic something the defense lawyer does?" Yeah, I mean, absolutely. They like to delay, because if they delay, they don't have to pay you money. So that's one of the number one tactics that they do. And Ben also says, "If the insurance limit is 1 million and the case goes to trial, can you get more than 1 million with the jury awards?" You can, but it'll be hard to collect the actual money unless you've set them up for like bad faith or some other method, unless your state has bad faith law, because, the jury can give you anything. The jury can give you $100 billion, but if there's only 1 million in insurance, that's how much there is to actually take the actual money. But yeah, the jury doesn't hear about insurance. So the jury doesn't know that there's 1 million, right? Insurance is something you cannot mention in a jury trial. And Drew also asks, "Injured in a 2024 work accident, ACDF, that's anterior cervical discectomy and fusion. That's a real serious surgery, and also a laminectomy, lasting bladder and nerve injuries, MMI in April, discovery ends in November. When will they try to settle?" Well, I mean, it's hard for me to know, exactly when they're going to settle. A settlement could happen at any time. You could settle the case now. They might never settle. They might offer you a low ball, which is only pennies on the dollar, and you have to get closer to trial and you'll settle it then, right? It's kind of like having a crystal ball and knowing what's going to happen. No one can tell you what's going to happen. But usually with a case like that, if you're reached maximum medical improvement, you're done treating, discovery ends in November. It depends on when you have your trial date. If your trial date comes up fairly quickly, I don't know what state you're in. Like in New York, you could be done with discovery in November, but your trial might not be for 3 years. So then you'd have time to settle, to do mediations, to do trial prep, and then everything. So a lot of cases settle closer to trial, but some cases settle after discovery. So I would say definitely, like, if you're trying to settle it this year, I would try November, December when discovery ends. Maybe send them a settlement opportunity letter and see how they respond. And if they don't give you a fair settlement, then hey, I have to like dig my heels in and prepare it more for trial, and I'm going to settle it a little bit later. So that's what I would say to that. And Willie says, "Good afternoon, Arkady. Hi, how are you?" And then Corey asks, "I had a ceiling collapse on me. I had 6 injections, both knees, 2 cervical, 2 lumbar. I also had 3 surgeries and an ACDF, that's the anterior cervical discectomy and fusion. Again, very, very, very serious surgery. Left knee surgery and right shoulder surgery, cases against the New York City Housing Authority." Okay, so that's a good case. That's a really good case. That could be a big case. Now, with the New York City Housing Authority, it could take some time because it's the city. It's like a city entity, and they're very slow. But the case is, it could just take some time. But I wouldn't settle it for like pennies on the dollar. I would let it ripen, and then when it's ripe, at trial, or it could be a big, big case, as long as you have the right people working it up properly. And then Nene says, "What happens after a standard appearance and all documents is given from both parties? What's the next step?" I don't know what you mean by standard appearance. Like if you mean like a compliance conference and then everything's been complied with, then the case could be, the judge could just say, well, everything's been complied with, so now you're going to get a trial date that it's certified, as trial ready, if that's what you mean. But there's no such real thing as a standard appearance. So I'm not really sure, and I'm not really sure what documents, but if there's no more discovery, like if all parties have been deposed or questioned under oath and you have those transcripts and all documents that you're trying to get and that the other side is trying to obtain from you, if all the documents and all the depositions have all been done, then the next step is to certify it as trial ready, because that's known as all discovery has been done. In New York, we call that filing a note of issue, and that puts the case on the trial calendar. But in other states, they might call it a certification, that you certify the case as trial ready. They have different names, but it's basically the same thing. And then Drew says, also, "We did the deposition end of August, to which my lawyer said I did phenomenal, while the other guy lied because his lawyer apparently didn't tell him there was a video of the rear end." Oh, so that's good for you. Yeah. If there's a rear end, you could also file a motion for summary judgment and get judgment as a matter of law. So then you already have a judgment. And in New York, if you have a judgment like that, then you get 9% interest. So for example, if you file that motion today, get a summary judgment, if you got rear-ended, then if the case goes to trial like a year or 2 years from now, well, you go back to the date of the order granting summary judgment, which is, let's say, today, and then you get 2 years worth of interest at 9% per year. So that's a lot of money. If it's like $1 million, let's say, 9% is like what, $90,000. But for 2 years, you get $180,000 for every million. But if you had all those injuries, like you said, with ACDF, it might be worth more. It might be worth like 4 million, 5 million. So it could be just the interest could be like close to $1 million. So it's crazy. You could do really well with that. And then Ben also says, "I'm suing New York City and the private contractor where I slipped and fell. The council motion to consolidate both cases. Does that mean I am limited to the private insurance of the contractor?" No, no. It just means that they're consolidating both cases. For whatever reason, the lawsuits were filed separately as 2 different index numbers. So they're just going to consolidate them into one, but you still can sue both defendants. They're still in the case. They just don't want to have 2 separate cases, right? Because then you'd have to have like one jury trial with one defendant, like the city, and then another jury trial with another jury at another time against the private contractor. They don't want to do that. It's not efficient, right? It doesn't make sense. It's the same incident. It's all one incident. You fell down, and it all happened because of one incident. So yeah, so you have to consolidate that. And a car says, should I be worried that my personal injury lawyer is a former defense lawyer for insurance companies? Grade 3 ankle sprain, 12 weeks of physical therapy, 3 allograft injections with aggravation of migraine, 6 ER visits. I mean, it's hard for me to say, like, personally, like, I think I did a video about it, or it might have been a short that came out recently. You could look on the channel. I personally, like, I think, like, the problem with insurance defense lawyers, they just have a different mentality. It's almost like, learning a language, right? If you speak a certain language, like if somebody speaks, let's say Chinese, they have that mentality. They know how to speak Chinese, right? If someone else speaks a different language, like, I don't know, like Polish, right? They have that mentality. So my point is, like, insurance defense lawyers, they have a certain mentality. It's more like a 9 to 5 mentality. They leave at 5 o'clock. They want to bill by the hour. They don't have that kind of passion where they're trying to help the injury victim, that they really care about the injury victim. They want to go to the injury victim's house. They want to break bread with them. They want to find out their human story and see, like, who is this person? Like, what was their life like before they got hurt? Like, what hurdles or barriers did they have to overcome? And what's their future going to be like, right? That's a deep dive. That's like a biography. They're not necessarily all going to, and I'm not saying some of them may do that, right? Some of them may have like almost like an awakening and do that. But I feel like there's like a little bit of a distinction, because a lot of insurance defense lawyers, they're being paid by the hour by the insurance companies like State Farm, Geico. They're making like, billions, like $90 billion every year. And they're being paid to then go into court and destroy these cases, delay the cases, dismiss the cases on technicalities, and basically hurt these injury victims. So if you did that for many years, you're like indoctrinated with that mindset. Now, for you to be able to completely switch, like a light switch, turn that off, and then go into court and now be an advocate that's passionate and really care about injury victims and get them millions of dollars. I mean, it's possible, but it's not easy, right? Because you've been indoctrinated with this mindset that everybody's like a liar, a cheater, and a fraud. They're all a bunch of fakers. That's the mindset that these insurance companies indoctrinate into everything, right? And that these cases aren't worth anything because people are trying to win the lawsuit lottery, and just the general what I'm seeing. So then if like a lawyer comes in, I mean, maybe they could switch. I'm not saying it's impossible, but I like more the idea of a real plaintiff's attorney who's always been a plaintiff's attorney, who really cares about, plaintiffs, injury victims, and trying to help them and do whatever they can for them, and like a real warrior for justice that's passionate. That's much better for you, as opposed to, an insurance defense lawyer. But, I do have to say, an insurance defense lawyer probably sees a lot of cases because they used to defend cases. Now they're prosecuting cases. So they see them from both sides. So they're very experienced. They know some of the tricks, right? Because they were the ones doing these tricks to others. So I can't say, it's like, if I say it's always bad, it's kind of like categorical, almost like a stereotype. And I can't say it's always good. So it just depends on the lawyer. If you're happy with the lawyer, of course, let them handle it for you. But if you feel like somebody else would be more passionate and would be a better advocate for you, then that's your right too, to use somebody who's a more passionate and maybe is a plaintiff's attorney. Okay. And then Billy asks, in my deposition, I brought up my enlistment in the Army. The defense requested my Army records, but I had no injuries. If I had been in a fight, could that be bad? Should I expect offers after if they can't prove nothing? So I'm not following. So in your deposition, you said that you had enlisted in the Army and the defense requested your records, but you had no injuries in the Army? And this is before your accident? I'm not really sure what the I mean, if you, like, for example, were in the Army after you got hurt and you testified that you can't do certain things, but then the Army records show that you passed and were able to join the Army, you have to be physically fit, that would hurt you. But whatever happened before you got injured I don't really see how that would actually help you, because it would show, hey, you used to be in the Army, you used to be like really physically fit, and now you're hurt. So I guess it would depend on what the case is about, like how you got hurt and and more about that than about the records themselves. Okay, and then Only Pure says, "Hi Arkady, thanks for the live consultation last week regarding the snowplow accident. The defense offered 750,000 for the first settlement. Our demand is 1.8. Is that a good start?" Yeah, I mean, I would say that's a good start. But I remember we talked, and the issue there is that you want to know how much insurance there is. You don't want to demand 1.8 if there's more, right? Because if there's more insurance and it's not just 1.8, it's like 5, then the 1.8 isn't really a good demand. So like I think we talked about that. So that's what I would say. You know. One second, let me just check something here. Okay, so we did that one. Now, Money Dog says, question, can I collect for damages to my credit in my TBI case? I don't think so. Credit? You mean like if you didn't like your credit was harmed or your credit score went down? I don't think so. It's an injury case, so it's more about injuries, like bodily injuries, physical injuries. Okay, and then Virgo asks, are my cerebral palsy and vision issues factors of contributory negligence, or does that only apply if I was behaving dangerously in the grocery store? No, I mean, it's not really a contributory negligence. Contributory negligence would be like you have to do something that's negligent, right? Meaning you didn't use reasonable care. So the fact that you have a condition is just like a medical condition. So, you just have to be reasonable as a person who has like a condition like cerebral palsy or somebody who, the same reasonableness that a reasonable person with like low bad vision or legal blindness would have, but no one's going to like punish you for having those medical conditions because that's not your fault, right? So I wouldn't worry about that. And then the truth says, what's better, arbitration or litigation in an Amazon case? I would say probably litigation because you can get a lot more. And a lot of the trucking lawyers that are excellent attorneys, what they're doing is they're holding Amazon to be not just a shipper, but also like a motor carrier, right? Because they use those DSPs, the delivery service partners, but they're actually a motor carrier. And if you could show that, then Amazon is on the hook and they have like millions and millions of coverage. So you could do really well with Amazon cases if it's a serious case, serious injury, I mean. And then Sam says, I have 4 disc herniations, pain in my neck until the arm and hand and left leg and foot. My lawyer wants to settle the case before to get the surgery. The doctor also recommended 4 facet injections. The insurance is 1 million. How much is my case worth? Well, I mean, I don't know. Like, I can't really answer these questions about value without knowing a lot more information. That's why I was saying, like, for value, it's better to just text me. It's 347-566-9595. And I could do like a consult call, which is free. Because for value, I really have to know like where you are, your venue. I have to know like what happened, how you got hurt. I have to just do a little bit of a deeper dive. It's really hard to put value on cases based on a comment of like one sentence. If anybody could do that, it would be like miraculous, just like incredible. It's almost like having a crystal ball and be like, you get 1 million, you get 2. It's like nobody could do that. It's impossible. So yeah, so you know what I'm saying? So basically that's what I recommend is a consult. But based on your injuries, I mean, look, yeah, your arm and hand, your left leg, um, I mean, you're just saying you have pain, but like pain could be really bad condition that's medically diagnosed, or it could just be pain. You know what I mean? Like that goes away. So which one is it, right? I'd have to know what your injury is. I mean, 4 disc herniations could be very, very serious, and that could be worth a lot. Um, and then you said to get the surgery, but what surgery? You have to be really specific because a surgery like a fusion for the disc herniation could be worth like 3 million, right? But if it's just like another kind of surgery, then it could be worth a lot less. So I can't really tell you without knowing a lot more. But Oh, he said microdiscectomy. No, microdiscectomy could be worth a lot. It could be worth, like in New York, I've had microdiscectomy cases go for like over $500,000. So it could be worth a lot. And then Corey says, can you throw me a wild number you think I should sit at for my case with the ceiling collapse? I mean, again, it's better to just text me. If we set up a consult, I could speak with you. We could go into everything in depth. It's just the way I like to do things. I don't like to just throw numbers around because it's not really, it's like closing your eyes and throwing a dart. You might hit, you might not. It's like, I don't want to, it's not really accurate. I don't want to be inaccurate. So let me know. It's free. You could just text me. I'm happy to do a call, maybe even tomorrow. And then Only Pure says the defense made an offer of $750. Our demand was 1.8. Now my lawyer is stating he wants to drop the demand to 1.5. Why would he drop the demand? I'm confused. I don't know. You have to ask him. It's hard for me to say, because the issue there is I think the lawyer should find out how much insurance there really is. If they can confirm that it's only like $1 million or whatever they thought it was, but they have to really confirm that 100%. You have to get excess policies, affidavits of no excess. I think we discussed all that when we had the consult. We had like a long consult and we discussed all that. So I think it's actually recorded too. You could watch the video. We talked about it. That's what you have to do. You have to get that. Now, once you know, hey, there's a certain number and there is no more other than that number, there can't be a penny more, then you can consider like lowering the demand if you want them to come up or whatever negotiating method they're going to use. I don't use that method. I don't like that method. I like to just tell them, hey, this case is worth X. This case is worth, let's say, $1 million. Pay me the $1 million. If you don't, that's fine. But when I go to court, it'll be $3 million, right? So I'm going up and I'm just, basically like a train. But what they're doing is they're trying to go down from 1.8 to 1.5 to get them to come up from 750 maybe to 950 and then push the 950 on you or whatever. Just an example. That's what they're trying to do. And that's an very old school way of negotiating. I don't like to do it that way, but a lot of lawyers do it that way. And then Ben asks, had an ACDF in July. Do I still continue seeing my pain management doctor, or is the ACDF supposed to be relieve pain where I no longer need to see a pain management? Yeah, I mean, if the pain management is helping you, you can continue to see them, of course. And Corey says, I have texted you, haven't heard back. In your expertise, ceiling collapse shouldn't happen, so I can't lose, correct? Well, no, I mean, any case could be lost. I mean, there's other issues you could lose on. If I didn't respond to you, just text me again. I'm happy to, I was away for a bit, but I'm back now. So I could, like I said, I could speak to you tomorrow. So no problem. Mediation before deposition, defense offered $125,000 saying I was warned. My timestamp shows I was at work. How will this affect the case value? I'm not really sure what this is asking. So the defense offered you $125,000 saying that you were warned and your timestamp shows that you were at work. But at work, at what point? I'm not really sure what this is asking. I'm sorry, I'm just not really sure what the question is. So the mediation happened before the deposition, which is, I guess, okay. And they offered you $125,000 saying that you were warned about the dangerous condition, that you shouldn't have had the accident. Is that what they mean? And your timestamp shows that you were at work. And did you get hurt at work? I'd have to know, again, I'd have to do a consult with you. I'd have to know like what happened, go into the facts. It's very like, oh, you were warned about the dangerous condition. Well, I mean, if that's true, if you were warned, then it makes the case a little bit harder for you, obviously, right? Because if you know about something, you should avoid it. It's just a reasonable standard, right? Who's being reasonable? Are they being reasonable? They could be negligent and allow the dangerous condition because they warned you, or are you reasonable that like, would a reasonable person still step into a hole if they knew about it, right? So it's just a reasonable standard. It's really simple. Well, he says he was not warned. So if you're not warned, then you're good. It's just their argument. So you just have to be persuasive and show that their argument, the defendant's argument, is a bunch of baloney. So you should be fine. And then Dasani says, would I be held at fault for not treating because I was waiting for a claim number from the city of New York? This has caused me a gap. Yeah, they probably would. Not in terms of fault, right? You wouldn't be at fault, but you would get less damages because if you're not getting medical care, then they're going to say, well, now your injuries aren't as serious, and the case has a lower value because you could have gotten medical care, but you chose not to, or whatever. You're waiting for a claim number, whatever the excuse is, but you're not getting. If you're really hurt, you're going to be getting more medical care, so that makes the case worth a little bit less. And David says, are multiple disc bulges valuable? I mean, they could be, especially if you do surgery or injections for them. And then Virgo says, my surgeon said he recommends physical therapy for the rest of my life. The insurance won't pay for that, and I can't afford it. How can that impact my case value? So what you have to do is have your surgeon write a narrative report explaining that, then have the economist extrapolate those numbers and put that into like a life care plan or a future medical prognosis. So for example, physical therapy costs like $100 a session. I'm going to need, let's say 2 sessions a week or whatever it is, like, 4 sessions a month for the rest of my life. So over the course of your life, depending on your age, that could be economic damages of millions and millions of dollars. It could be like close to 3 million, right? Because it's not just physical therapy. It's also going to be like prescriptions, future surgeries. It could be like MRIs, X-rays, whatever you need medically. So those are known as future medical costs, and they're economic, right? Because you could put a price on them, and you could look in the community where you live. What do these things cost? The doctor could talk about that. The economist could talk about that, or you get a life care planner, and that's known as economic damages. You're entitled to that, but you need to have like a trial lawyer, build that up the right way. And then let me see. Oh, TMC says the mediator said if I was able to provide timestamps of me being at work, it would poke holes in the defense story. And he did provide that. Okay, so then obviously that's good for you, But I don't know, like, again, I don't even know what you fell on, or like whenever we do the consult, I like to start with just like what happened, That's always a good place to start. Because if I don't even know what happened, but I'm answering other questions, then you know what I mean? I don't have the foundation to answer anything else, like, because you're asking really specific questions about like timestamps, but I don't even know like what happened. You know what I mean? So for me to answer, I could be very, very wrong, and I don't want to give you misinformation. So again, the best thing to do is just to text me 347-566. I'll drop it in the chat as well. 9595. That would be the best thing, because then we could like find out what happened, do a consult. I can give you information. Some of the consults I'm recording, and then we could, of course, we take out anything confidential like name or, whatever you don't want in there, but just the general fact patterns or general questions could be useful for others. So sometimes we record them and then we use them as videos, but you don't have to get it recorded. You could do the consult without recording it as well. And then Dasani says, why attorney doesn't get charged for not helping clients do what's necessary in personal injury cases. Get charged? I'm not sure what you mean. If the attorney doesn't help? I mean, if the attorney's not helping you, just get another attorney. It's your right to hire an attorney that will help, that you're happy with. Okay, everyone, I have to run a little early today, but we've been about 40 minutes. I think we answered most of the questions that are here. And we'll do another one, maybe like even tomorrow, or if not tomorrow, then early next week. Okay, everyone, thank you. Please like and subscribe to our channel. Let us know what questions you have. Let us know what videos you want to see in the future. We are here for you. Our goal is helping serious injury victims and families. All the best. Okay, bye-bye.